Hello again, hope you're all doing well. Today's video, it's a rush job. Apologies for that, but hold tight, we got some cool stuff for you. I just gotta be quick. First, if you were at an Imagine Theater over Father's Day weekend, you saw the theatrical debut of my children for their Father's Day promo.
What makes my father special is where he took care of me and my siblings when we were a lot smaller.
Because he is really awesome and he is really good at cooking. And he gives homes to animals who need it.
I don't know about you, but that was the coolest Father's Day gift I have ever gotten, period. Anyways, I covered TPRs previously, and to sort of celebrate the release of the new quarterly guide, which covers 25 decisions from January through April of 2025, I'm doing it again. But wait, this time I'm doing something different. This video is going to focus on cases that involve universal trial issues, things that come up in any kind of area of practice. And one of those is due process, and this is Myra. And if you don't know, she's like the Pedro Pascal of appellate lawyers because she's sort of like in every appeal these days. Relocations, cohabitations, suggestion 341s. Anyways, I begged her, like, if she could do a blink and you'll miss a cameo, but she sort of mumbled something about over her dead body. Anyways, she is in our first case where she hits this kind of walk-off homer in a guardianship appeal, and I'm watering this down terribly, but in the case, the state jumped in front of Dad's motion, which was already set for hearing, with another motion that essentially did the exact opposite of what Dad's filing sought to accomplish. Hopefully you're sticking with me on this one. Well, anyways, Myra argued that this sort of leapfrogging violated due process. The appellate court was like, yeah, it does, and they reverse it. Now for my second case, well, I know a few of you have wondered, gee whiz, do you have any trivia on rolling objections? Which apparently are a thing. And my answer is, yes, I finally do. This case here says that they only exist, really, if a judge says it exists. So just telling the judge, hey, this is a rolling objection or a continuing objection to a line of questioning, for example, that you believe is going to be inadmissible, that by itself isn't enough. The judge must recognize it as such, especially if you need that objection preserved for, say, an appeal. And finally, for the final case, we have expert testimony. Well, guess what? There's no actual requirement that an expert say the magic phrase, within a reasonable degree of certainty. If they're an expert, it's basically implied. And if none of these make you happy, we got a few more here in the guide, such as offers of proof. Sometimes you actually don't need to do it. And how far can a judge go when they want to take over questioning of a witness? So even if TPRs aren't your thing, the guide has a few things that we all need to know to avoid angering these people. Anyways, like I said, this is going to be a rush job. I got to get back to work and on another project, which hopefully we'll talk about in next month's topic, which is visitations. And yes, I finally get to cover parenting time trends in family law. So if you want more information on all this cool stuff, stock the channel, stock the Substack to get notified when the free guide here has been released from the proofreader, which I'm guessing will be in just a few days. And with that said, as always, thanks for watching.
This is the story of Myra the lawyer. She filed every appeal, she filed every brief, and when in those relocations and guardianship case, she's the Pedro Pascal, but with a female face.